Should I begin? So, it is, thank you very much for the initiative and for the invitation. It is a privilege to be here in this foundation, and particularly with the people who have teams of the foundation, of this initiative. And the topic, so I'm going to speak with them, there are two experts to speak about, is about peace. And I remember just in a small note, but I think important, a Portuguese called Adriano Moreira was Minister of Overseas in '66 in the beginning, and so at that time Macau and Timor and all this, who had a censor which I quote very often, saying that Europe could not have the shame of beginning a new war, because they were called world wars, but the beginning was in Europe. So in the 20th century, my century. I was born during the Second World War, because I'm not, you are a little bit less young than me, but we both were during the Second War. And so it is so not acceptable. But we don't know what will happen now, because I was finishing a paper where I had mentioned that it is not possible to have now, in the 21st century, a war beginning in Europe. But after something, you know, in Ukraine, because Russia to some extent European, I had to, it was already in printing, to be printed, to change, I put another thing, I put, it is not possible to have, in the 21st, to have a war beginning in the European Union country. I hope I'm right, I hope so. But anyway, so it is a problem, so the two speakers are going to speak about them. They don't need so presentation. My colleague and friend Jonathan Machado is professor so in Coimbra, in law, connected mainly with political science and law, with very good texts, some of them more in my area, as taxation and about the European Union. So, and it is good because he has other areas, but these two which are more in my area of teaching. And so now he's the dean of the Law School of Coimbra, which has a very close cooperation with Macau. So it is wonderful to have here. So somebody, we have the Vice Chancellor, I shall not mention everybody here, so, but anyway, so who has made he's making a wonderful role with this cooperation, but it is particularly good to have here. And in the days I have been here yesterday and today, it was well stressed how law can be a wonderful way of making connections with territories, with China, and so it was what I have understood today. I was there all the day, and it was quite interesting for me, and from another area, not civil law, but it was very, very interesting indeed. So I ask Professor Jonathan Machado to take the floor, please.
Thank you, Professor Manuel Porto. It's a pleasure and an honor to be here in Fundação Rui Cunha, and to meet personally Dr. Rui Cunha. It's a pleasure, and it's a pleasure to be in this panel and to have been invited also by Professor Trigo, along with my colleagues from Coimbra and other universities. The topic that I would like to address is the importance of the European Union in promoting international peace and stability. Of course, it's a rich topic, and since you know, we have had a long day, I will concentrate on a few ideas, and you will do me justice, you know, in accepting that I could not cover all that could be said about this important topic. One topic, one aspect mentioned by Professor Porto was the fact that Europe was a continent that has been plagued by many wars during many centuries. You know, in the beginning, in Europe, the kings were very influenced by the Nordic sagas of the warrior kings, you know, that would fight each other and would drink the enemy's blood in its own skull. So it was, those were ruthless times in Europe. You know, this mentality of the warrior king. And then along came the Christian monks and the Irish monks, and they tried to civilize civilize the monarchs, the European monarchs, and tame their the propensity to war and to violence. And they offered another narrative, the narrative of the Christian king, the king that would comply to a divine law that was above the king, and that should be accountable to God, and that should be crowned in a church, in a cathedral by a cardinal or sometimes even the Pope. And so the idea was that there was a higher law above the kings to which they were accountable. But unfortunately, these Christian kings sometimes would fight each other to see who was the most Christian king. The English monarch wanted to be the prince of Christendom. The French monarch wanted to be the prince of Christendom, and the Spanish monarch also. So there was this tension: who is the most important king within Christendom? And so we had the medieval wars, the Wars of the Roses, the 100 Years' War, these dynastic wars in Europe that was plaguing the continent, even between Christian kings. And then along came the Protestant Reformation, and there was this split between Catholics and Protestants, but there was also this split between dynastic families, the split between the Bourbons and the Habsburgs, this very important split in Europe. And then along came the 30 Years' War, the religious and political wars. The 30 Years' War was a war that started as being a war between Protestants and Catholics, but then became a war between the Habsburgs and the Bourbons, two Catholic families that wanted to rule over Europe. And we know that in this war, 1/3 of the German population was killed. So these were barbaric times. And then along came the Peace of Westphalia, very important in the creation of a spirit of cooperation and this idea that a big multilateral treaty should try to impose some peace and stability over the continent. But as you know, then there were the colonies, the colonization. The Portuguese had their colonies, the Spanish had their colonies, and then along came the British, the Dutch, the French. And so in the 18th century, these rivalries between the European powers over the colonies, over the colonies. And so there was this tension, this rivalry between these powers, Portugal and Spain, then Portugal and Spain and England in the Invincible Armada, 1580, and then the conflicts between the French and the Dutch, the Dutch and the English, the French and the English, and so we see this continuous conflict in Europe now over resources, over gold, over silver, over the control of the markets, over the control of resources. This will to power and this will to money was very important. And then that Napoleon came. He tried to change the game in the favor of France in the early 19th century, but then he was defeated, and the British Empire came to be the largest empire in the world. But in the 1870s, there was the unification of Germany and the unification of Italy. And these new powers were not pleased with their situation concerning the colonies. They thought that the Portuguese, the Spanish, the British, and the French, they had more colonies and more power than the Italians and then the Germans. And also Russia was also resenting this situation. And then you know that we had the conference, the Berlin Conference in 1885, in which the big powers decided to a best way to distribute the colonies. But the Germans were not pleased, the Italians were not pleased, and so we had the First World War, and then the Second World War. So we have a history of war, for many purposes. It's interesting that Thucydides or Thucydides in his book, in his famous book on the wars of Peloponnese, he has a list of reasons of why people go to war, and the list is immense. There are many reasons why the countries go to war. Religion is just one of them, and it's interesting that Thucydides doesn't even mention religion. He mentions many other kinds of reasons why countries go to war. And so the European countries went to war. And as Professor Porto has said, the war became a world war because the colonies were at stake. It was like poker, a poker game. If you win everything, if you win in Europe, you will win all around the world. So the stakes were high. Many people died. And so the situation evolved into, after two terrible, devastating wars. There are some people that say that the First and the Second World Wars were really one world war, a second 30 years war. So there is this theory that because it's the same war with an intermission, and then a second part. First part, an intermission, and then a second part. But it's the same war. And so, because of this tendency to war, there had already been some proposals for the creation of peaceful institutions in Europe. For instance, in the 17th century, after the British Civil War and after the 30 Years' War, William Penn, the founder of the American colony of Pennsylvania, a Quaker, a British Quaker that went from England to the New World and founded the colony of Pennsylvania. He proposed the creation of a European Parliament. He proposed the creation of a European Parliament and European institutions in the 17th century. And also we see in the turn between the 17th century and the 18th century, another philosopher and clergy of France, the Abbé de Saint-Pierre. He was a noble philosopher. He came also with he was very active in the negotiation of the Treaty of Utrecht that put the end to a conflict, a dynastic conflict in Spain, you know, because there was this, also again the fight between the Bourbons and the Habsburgs, and so there was this potential war again, and the Treaty of Utrecht, which the Abbé de Saint-Pierre helped in negotiation. He wrote about the need to come up with some European institutions. And also in the 18th century, also Immanuel Kant in the 18th century, in this treaty on the perpetual peace, actually the Abbé Saint-Pierre treaty was also on the perpetual peace. He also proposed the creation of this pan-European institutions that could help the countries to avoid war, because it was clear that in Europe there was a tendency to war. And so, drawing on this and other proposals, even in the 19th century, there had been several proposals to create some kind of a world court or a European court inspired in the American federal court, you know, because in the United States there was a federal court that ruled over the states. And so there was also this idea in the world or in Europe, we could come up with a court that could rule, you know, settle the disputes between the countries, as the American federal court does with the disputes among the states, because it also has that competence. So there, you know, there were these precedents, these ideas. And of course, after the Second World War, you know, these ideas gained another stronger force, and so there was the creation of you know, first there was this idea, you know, the prophet Isaiah, in the beginning of his book, he writes about how it would be good if the peoples would cease to wage war against each other and would turn their agricultural instruments into, or their weapons, they would turn their weapons into agricultural instruments and promote the peace. And so we had this idea, the creation of a community for carbon and steel, and also a commission for the ruling, the regulation of atomic energy. And it was the spirit of trying to transform natural resources that can be used to wage war, to transform them in instruments of peace and economic prosperity and growth. So there was this idea, and there was also the idea of creating a European community, a European economic community, in which the evils of protectionism, of nationalism, economic nationalism that led to political nationalism and to political militarism, you know, to try to promote a different attitude. Because some philosophers, for instance, Pierre Bayle and Voltaire and Immanuel Kant, they had said that if the nations exchange between themselves goods and services, they will be creating a climate of toleration, mutual comprehension, mutual understanding, and so. Because Voltaire and Pierre Bayle, they said, you know, in the markets of Baghdad or Basra or Oman, we see that people trade goods and services, and they don't they are not killing themselves over religion and things like that. So there was this idea that by stimulating trade and commerce between nations, the conditions of peace could be promoted. So there was this idea, and there was also the idea of creating a European Parliament. And as you know, of course, we will not elaborate on this, but the creation of the European institutions is based on these proposals, and these proposals also show as that sometimes even utopian ideas that may be that we may have today, they may be fruitful. They may fructify 2 centuries in the future. So we see that William Penn, Abel de Saint-Pierre, Immanuel Kant, they came up with institutional ideas above their time, you know. But these ideas were useful because later on others were able to draw on these ideas and to develop political institutions. Just to come to a closing, it's very interesting also in the European institutions the way the Council, the European Council and the Council of the European Union, 2 councils, they work. They remind me a bit of the story of King Arthur and the Round Table. You know this. I don't know if all are aware of King Arthur and the Knights of the Round Table. You know, the British tell this story about an old British king, probably one of the first British kings after after the Romans left Britain. He used to sit before a round table with his knights, and they will rule over England with a round table. And this is very interesting because if anyone would enter the room and he would see a round table with the king and the knights, but he could not tell exactly who was the king and who was the other knights because the table was round, and so they were in a situation of equality. And so the Council of the European Union and the European Council, they operate according to this round table principle, this principle of equality between the states. Of course, there are other logics, there are other logics of representation in which the differences of population and political power have to be taken into account somehow. Of course, it's an imperative of the democratic principle. But there is also this mitigating idea, the round table principle, this principle of dialogue. And remember that it is dialogue between the leaders of nations that have a history of fighting each other, over many topics, over many issues. So, and this was such a powerful contribution for peace in Europe that the European Union was awarded with the Nobel Prize because of this feat. As Professor Lopes Porto said, this hope that there won't be war, at least not initiated by the Europeans, by the European Union within Europe. So this is for me very important. This contribution of the European Union to promote peace within Europe and even outside Europe. We could speak of the European External Action Service and the way and the European Peace Initiative. Of course, we could talk for many minutes or even hours on these topics, but but I want to do that. But just to remind that even the territory of the European Union, you know, what we call the Schengen area, as a name, you know, it is the area of freedom, justice, and freedom, security, and justice. So these are the values that the Europeans want to promote within the European Union and outside the European Union. If they are successful, I don't know. We know that the challenges are immense. We have the election of the United States around the clock, and we don't know exactly what will happen concerning, for instance, the defense of Europe and things like that. We have the problem with Russia, and we know how you know, even energy supplies were so vital for Europe coming from Russia. And we have also the relationship with China now with this trade war between, you know, involving electric vehicles and other many other products, and we don't know what will come of it. But my hope is that in spite of these challenges, the European Union can be a partner for peace. And I hope that with China, for instance, Europe and China can draw on the relations, that the historical relations that they have with each other, and also with India, the historical relations that we have with each other, and with other continents in America, North America, South America, Africa, and learning the lessons of history, and also drawing on the bonds that history has created between us, we will be able to promote peace and security for the sake of ourselves and for the sake of our sons and the sons of our sons. Thank you very much.
Many thanks, Professor João Machado, for presenting so clear in picture of the way the manner of Europe along the last centuries. Now I give the floor to Professor Bruga Perumal Ramaswamy. So it's a very important, interesting curriculum. So having the MPhil in New Delhi, so the PhD in Hong Kong, but being professor here, so very well known. It is not necessary to say more about. He is very well known with work he has done. And he's going to speak, as far as I saw, about Asian responsibilities. So it is another of word in which I'm involved for family reasons. Two people at least in this room, and myself. So please take the floor.
Thank you. Thank you, Chair. Good evening, ladies and gentlemen. First of all, my gratitude to Rui Cunha Foundation for having me this evening to share some thoughts on the continuation of where Professor Machado left out, like to supplement a regional focus on what a regional body is doing. Of course, it's unparalleled, of course, in a negative way. There's a lot of limitations with regard to what's going on in Asia, especially in terms of this collaborative platform. So I initially thought I would take up a specific country like what India is doing or China is doing with regard to contribution to the peace initiatives and under the auspices of the United Nations itself. They've done some very important contribution for peacekeeping missions or having like peacekeeping troops sent to a neighboring region. For example, India has done this in Sri Lanka, and that has kind of had a big cost for India, ultimately the life of the Prime Minister himself at some point, who's suspected to have been assassinated as a kind of revenge for that peacekeeping thing. So there has been a lot of very important historical events in which independent Asian countries have kind of volunteered to contribute to peace missions, and there's all positive and negative outcomes resulting from that. But then I thought that that may not rather be suitable for this occasion to probably have a more comprehensive, collaborative regional entity doing this. So I tried to look into what the ASEAN is doing. ASEAN, when the name ASEAN is heard by all of us, the first thing strikes to us is more like an economic community trying to sort of facilitate trade promotion between the member states. And also their interest for ASEAN Plus, other countries trying to join with them. So it's a very formidable thing is unity coming there. Nevertheless, there are two other hidden elements with ASEAN, which is less known, but then ASEAN takes pride in going beyond economic cooperation. This is the political and security community of ASEAN and also the social cultural community of ASEAN. So they have a blueprint which has been there for a while now, in which they very conspicuously proclaim and point out to this very three important mission of the ASEAN. But unfortunately, when one takes a closer look into what they have been doing, especially in the context of political security community, there's been very disappointing in terms of what they have managed to achieve. At the very outset, I wanted to give some background on this, what's happening otherwise elsewhere. Of course, the European story is very different, but then I was yesterday talking in my own law school about one international initiative that has also very quietly come up last year, which is actually the Ljubljana Hague Convention. This is under the auspices of the Slovenian government, who took a lot of efforts to bring together this particular legal assistance on criminal matters convention, a very extensive one, very ambitious one, touching upon several aspects, targeting specifically on matters of very important crimes like genocide and crimes against humanity, war crimes. And of course, they have a second layer of possibility of undertaking obligations even on crimes or crime of aggression and other certain specific crimes. So I was pointing out yesterday why that convention, my question was whether that convention really makes a difference. Because when we all have this fundamental concept of jus cogens securing many of these crimes, of course, and we have the ICC to take care of it, the Rome Statute, and we have also the specific treaty instruments like the Genocide Convention and all the Geneva Conventions, and of course what the Sixth Committee is working now on, the potential convention on crimes against humanity. With all that being there, why do we need such a comprehensive separate convention? And I was highlighting the limitations of all these conventions, even Genocide Convention in itself, and also the Geneva Convention, several of them except some of the protocols, they all lack certain very important element of this fundamental principle of ad didere ad judice, that is either prosecute or extradite. This particular fundamental obligation is missing. And then I also highlighted to several other elements which are not there. For example, some of them having very specific application to the convention or the crime they govern. For example, the United Nations Convention on Transnational Crimes, Organized Crimes, and then on question of corruption, United Nations Convention on Corruption, etc. But then to show that even there, who have gone up and undertaken the obligation so far, it opened signature earlier this year, and this is February, they opened for signature, and we see the response has been a little bit lukewarm among certain countries who we would not expect that to be. Even I had some conversation before this talk. Some European countries have not yet come up and become party to this. But there's some very, at the same time, some interesting countries in Asia. For example, Mongolia has been one of the champion of this convention from the very beginning, and it is something to see very interestingly, countries like that coming up and signing. Around 34 have done this along with Slovenia. But one would say that in this context, we may want to think like what Asian countries are doing at different layers. But of course, at the international instruments like the one I mentioned, vis-a-vis other international instruments aiming to seek peace or justice in criminal matters, and then come to the regional one. And the regional one is my focus today, and I try to sort of have a kind of very comprehensive look into how these Asian countries are flagged up in international obligations. I also have, probably it's for another talk, to point out that their undertaking of these obligations or partaking in these further developments have been very disappointing as well. But coming to ASEAN, coming back to this platform of the Asia political security community, the ASEAN political security community, they have like very interesting things going on at the moment. As we speak, just around 10 days ago, in Vientiane, they had this important ministerial meeting, and especially what they call as ASLOM. And I tend to focus more on the legal issues, so I try to see that. This is actually a group of law officers from these Asian countries joining together and negotiating on these very important matters of judicial and legal cooperation. What we noticed is, as way back in 2002, ASEAN proposed one of the first treaties for mutual assistance on criminal matters. So since 2002, now we have around 22 years gone, this has not seen the light of the day, and it's still being in Vientiane as well, still under negotiation. Then the other element is actually a very important one, which I intend to focus today, is ASEAN extradition treaty. This ASEAN extradition treaty was also for a long time under the negotiation, and finally what they managed to come out with the model extradition treaty, and that was in 2018. And even since then they've been trying to convert this into a proper treaty which the 10 of the member states could sign up, and they had a lot of glitches, and even then they could not come to any conclusion. I'll come back to that in a moment, but I want to make one observation there. Today I'm planning to I thought originally I'll have a PPT to kind of take you through some specific aspects of that treaty, what is causing the glitch to them, and why that is actually manifesting this lack of consensus or lack of active contribution of these member states, even within themselves and vis-a-vis outside world, in undertaking international obligations for the purpose of contributing to peace and security. So that is the second element, and they also have a third element is with regard to a treaty they have been working on. It's a treaty for transfer of sentenced persons in criminal matters. And even the third treaty they could not agree upon. And for me, the extradition treaty is actually connecting all the three, and there are some very important insights to be learned from that one. So that is my main focus. But then to start with, I also wanted to say that they say this whole inspiration for the ASEAN political security community is derived from the ASEAN Charter itself. The Charter foresees, as we see that this is 1967, and since then they have this aspiration. So if you think about it, the ASEAN from the very beginning have this thing, and if you think about that from 67, more than 50, 55, 60 years nearly, they were not able to sort of achieve anything concrete and conspicuous there. So in this context, I'd like to straight away jump onto that specific ASEAN extradition treaty and point out some of the key elements I just wanted to quickly mention. And I'll stop it there to ask this question. And before going into that, I also wanted to tell something that may be relevant for our region, especially for China itself. The role of ASEAN in trying to sort of intervene in the South China Sea related challenges is also very limited, and they've hardly done anything. Individual countries have started to do that. Of course, one would think ASEAN would be able to sort of put forward a much more concerted effort to have a diplomatic exchange on this matter, which China is always asking for a diplomatic solution to that. And if not possible with individual member states, there could be potential for ASEAN to play a role there. which is also kind of quite limited. I don't intend to touch that upon, but I wanted to show that this particular issue, what I'm talking about, is not a distance issue for us. It still has that limitation. What I'm trying to point out also has implications for us to achieve peace in South China Sea itself. So in that regard, if one can go into see this, this model treaty or the issues that are coming up has several glitches. First of all, they have this disagreement with regard to the element of certain options they have with regard to go one way or other. The first element is, of course, with regard to the very obligation to extradite itself. And here there are two divisions. One is about whether they should undertake an obligation based on the spirit of the treaty, extradition treaty itself, or they should subject it to the national laws of the respective member states. This has been one of the very big challenging thing for them for a long time, because some of the individual member states, particularly that of before that, going to that, I also wanted to say, beyond the South China thing, I also wanted to point out why this significant thing is quite significant is because of certain historical things happening in Khmer Rouge regime in Cambodia, and also what has been happening with regard to the Rohingya refugee crisis in Myanmar. So even there in that frontier, you can see that it's involving these two member states, very important in regard to certain international crimes. This is of concern for the whole community, international community, for also certain specific states, and also in the region itself. So in that context, one of the problem is this obligation to extradite, whether subjected to the spirit of the treaty or whether it should also be subjected to the spirit plus the national laws of the respective member states, has been one very divisive matter. And secondly, with regard to this, they also have another question with regard to the element of course, the temporal question, with regard to the dates and others. Also, the date of commission of the offence or the act, when it should be, whether the treaty coming into force or subsequent to the treaty coming into force, or any time irrespective of the date. So again, one would say that given certain very serious crimes that have taken place, and of course law of limitation should not govern this matter, but countries are keen to make sure that okay, this treaty comes into force, and the extradition obligation will only be undertaken subsequent to the treaty coming into force. That's another very important divisive element between themselves. Then also, the other interesting thing is with regard to definition of what is an extraditable offense. And here, one could see that the attempt itself, even if this treaty materializes at one point of time, I have concerns that it's not really touching upon anything for which we may want this treaty to serve the purpose, like especially on those serious crimes, grave crimes, because these things are really addressing only matters that are of, in my opinion, a typical thing extradition treaty would have, like a series of groups of crimes. I don't have time to go through that. Had it been a PPT, I would have pointed out to some of them. But let me jump to something which they touch upon on international crimes of concern. Here they are talking about piracy, one element. Certainly that's of certain concern, like as we know that previously have been there in Malacca Strait and others. Then there's a question of certain elements of hijacking of aircrafts, terrorism, financing offenses, and hijacking of ships. Of course, one could think of this also as typical, but then going beyond that. But then comes our probably a much closer one for our international concern, which is about, of course, element of bribes, drug trafficking, and also other serious crimes defined by the Convention Against Transnational Organized Crime, which I pointed out yesterday also, which has its limitations as well, I pointed out. And then there is this thing, any other offense which is made extraditable by the extradition laws of both parties. Again, there is this very important limitation that it should be a crime that is extraditable under the law of both the parties, requesting state and requested state. It's not sufficient if it is even an extraditable offense under the requested state only. And also, this is also related to some international obligation, the convention to which both states should be parties to. Another limitation is if they wanted to kind of get into this, so obligation, they are insisting that such an obligation should be governing both. If one of them is not party to an international instrument, then this would not govern the matter. Unfortunately for me, the whole idea of having this treaty is to create this obligation between themselves, and then what they are saying is basically, oh, if you are not party to this international treaty, I would not undertake this obligation. They are excluding that. So I really don't know how this particular treaty they are planning to will supplement the international obligation. Then certain other things which I would skip in extrajudicial offense in the interest of time. Coming to certain other elements, this one is also probably I should touch upon, because there's one more limitation which is also quite strange in my opinion. So if the act or omission constituting the offense was an offense at the time it was committed and also at the time the request for extradition is received. So this is kind of a very interesting thing to say that, okay, like, look, it is not sufficient, it was a crime at that point, it should also be a crime at the time when it was also the request was made. And also at the time. So it's both of this thing, like, so if any of the states for some reason probably have brought in one of these elements missing, I don't know how this would be, but to see that being insisted again is one more question, whether it is typical or something unique here. There's also other question is the basis for which the extradition is made, the basis on which extradition is made. So here there is a lot of furnishing of information, evidence, document, even elements sometimes touching on prima facie case to be established or involved. Luckily, the prima facie requirement is done away with it. I'm happy, but nevertheless, the element of evidence and other kind of information they wanted to be furnished to the satisfaction of the requested state, it makes us wonder what is this cooperation is all about. So there is an element of always a lack of trust to a lot of ways in terms of this, and they want to have a very high onus of evidential standard for the requested state to comply with the request for extradition. That's again for me is a little bit disappointing. And also in terms of that, the requirement is which meets the evidentiary standard of the requested party for extradition. So it's not only X amount of evidence, they also insist that they can also challenge an evidence if it doesn't meet the evidentiary standard of the requested state. So the requested state, again, there is this element if there is a disparity in terms of evidential standards, and that may be a ground on which extradition may be denied. Also, there is the question of certain mandatory grounds for refusal. So this is also very conspicuous that some of them are really don't see the purpose in the light of the spirit of a corporation like a regional entity. So here, for example, if a person who's been sought for extradition has been acquitted by a competent tribunal or authority in respect of an offense of another offense constituted by the same act or omission or the offense for which the requested person extradition is requested. So that means basically what they are saying is if there has been a trial elsewhere, let's say if the requesting state would not have done it, maybe elsewhere this was done, because the language used doesn't say this was done like, of course, in the requesting state. So anywhere if this has happened and he was acquitted, that itself could be a ground, mandatory ground for refusing extradition. And this is very strange. And how about retrial? Sometimes new evidences can come about, and there could be a thing. And there's also another interesting thing, which in details it's hidden, is if, for example, at the time of requesting the extradition, if the competent authority of the requesting state has requested this on certain charges, there is a clause saying that they cannot go beyond those charges in the trial of that person. So let's say, for example, if there is a ongoing investigation and if they discover new trial and if they wanted to sort of also bring in new charges, probably a retrial or even in the same thing, probably a revised charges formulation, etc. They are all going to be impeded by this provision saying that the person can only be confined to the charges on which they've been originally requested. For me, some of this may be typical for individual or bilateral extradition treaties. But for me, the whole question I am raising is, this is a platform. What is the role this has to play with ASEAN extradition treaty? Why not you make, each one of you a bilateral treaty among yourself, among the 10 members, they could make bilateral extradition treaty. So if at all you are making one under the auspices of a regional organization, and there should be some element of trust and there should be some element of flexibility, and strictly confining these things to those typical standards. Some of you may think that this is typical of extradition treaty elsewhere. That is true. Elsewhere that may be there. But then here my question comes in the light of this cooperation. All right, I'm going to skip the mandatory grounds. There are some very disturbing to say for me, at least. This also sometimes even alludes to question of lapse of time for certain things, and even amnesty, things like that. Again, probably one got the amnesty when the regime did not change at that point of time or whatever, and then that in itself could be concerns there. And also there are very interesting things which are paving way to this complacency, if I may call that so, because of trying to keep up the political relations between some of these member states, or their allies in certain matters, standing together. The provisions may lead to such complacency in terms of taking a blind eye or closing your eyes towards something which could have been served well had those provisions not been there. There's also a big concern, other than mandatory grounds, there's a whole set of discretionary grounds of refusal. That actually takes me to really a laugh, because those discretionary grounds really are, for me, ridicule of this whole cooperation. This discretion goes actually beyond, an unfettered discretion. For me, it's really an unfettered discretion. This is something gives room. Again, I don't have time to go through that. I wish I have more time and to point out to some of how this really would waters down this whole effort. Moving on to the other ones, again, this is understandably so, but then there are some specific things. This is involving the request to extradite a national of the requested state. Again, countries are typically very fuzzy about this, but here the element is also having its own concern of how they wanted to construct and limit the nationals in this context itself. Other than that, there is this provision of provisional arrest even before a proper serving of all the documents for the extradition. It's for me a positive thing to apprehend a person, otherwise he may abscond. So the provisional arrest provisions, I see this positively, but I don't know whether this would actually in reality make any difference, because there's also some very interesting, or rather, what would I say, loopholes in that. For example, after the provisional arrest is made, the requesting state is expected to act very fast. The timeline given to them is very, very short, in my opinion. If they kind of don't complete the request for extradition process, the provisional arrest thing would be without, of course, proper involvement of them, be released abruptly. And then, of course, with the provision saying that, of course, when ultimately they intend to serve this, they will try to apprehend them again, try to extradite them. For me, there is a possibility for cooperation, because this is not states who you are not rather connected with. You have a regional forum, you have exchanges, you have the legal officers cooperation forum very regularly meeting. Why not, like for example, if someone made a request and you made a provisional arrest before they could serve, then you could in collaborative way get that thing achieved as soon as possible. So those things, again, in the spirit of cooperation, for me is a concern. And other than that, with regard to some matters of confidentiality, with regard to these matters, again, I will skip that. There are some elements of small concerns emerging that. With regard to the language, again, of course, the English is foreseen as a common thing for this, all these documents. But then there's also, if the requested state insists, they wanted that to be in the language, official language of the requested state. And this is, of course, for me, is okay because it's typical, but then again, the cost of that is to be borne by the requesting party. So again, there is doesn't seem to be anything done at the level of the corporation itself. Then the question of concurrent requests made by certain parties here, one interesting thing what they foresee is a concurrent request made by a member state of ASEAN and another state which is not a member state of ASEAN. And in that context, for me, I don't see a priority or some sort of preference given to the member states. In one way, probably it's good that they treat all equally, but then again, the question of cooperation comes, and whether is it just the question of who made the request first, or they should go beyond and see where the trial would be held in much more fair manner. And I would have thought that going in that direction and finally giving some principles or obligations to support that, where the justice will be served better, should be the standard, in my opinion. Yes, I'm going to, in the interest of time, and as Chairman rightly reminded me, there's no stopping. So let me stop here by saying some concluding words. For me, certainly the role which ASEAN is playing with regard to the political security community is very minimalistic. It's more formal in terms of paper than action. It's in no way comparable to what has been done by other regional organizations elsewhere. I'm very critical about this. Going beyond EU, I would say that some efforts we see in African Union or even the Organization of American States, I would say, are much better than ASEAN. So if ASEAN is really serious about this triple mandate they have, and they wanted to have a more balanced approach, I could see that economic factors are driving more than others. This can happen everywhere, but then learning from EU, the balance, they are talking about, some of my colleagues were also talking yesterday on environmental matters and how do you seek that balance. This is very critical for any regional organization, let alone ASEAN. And I hope that asserting that role, ASEAN would play a very important role, because this is one very prominent regional one. And of course, for us also, such a concerted effort by them could make peace in this region in the future much more feasible and successful. Thank you, gentlemen, ladies.
Thank you very much, Professor, for so interesting presentation from so important, increasing important area of the world. So two areas were here, especially mentioned. I think we have some time. So in this case, what I also is to have the question where there are questions, or where there are contributions, welcome. But more important for me, disagreements. So I am used to have this kind of presentations. To have contributions is useful. Questions, of course, we to understand. But if there are disagreements, it will be very interesting at the end of this afternoon, wonderful afternoon. Does anybody want to take the floor? Not only about disagreements. So if it is not the case, it is approved by unanimity. You are in China. No, you are in China anyway. So it is. You are here in China, unanimity. Please, Paul.
Thank you very much. I'd like to raise questions to Professor Jonathan Machado. I know I have the opportunity normally to talk with him, so I'm doing this here publicly also because I think I know his answers, but I would like to see him elaborate on this. And first of all, I would like you to comment on the fact that it seems that at some borders of the European Union, some enlargements are seen or are at least pretexted to be threats. You see, for instance, Russia is constantly saying that the enlargement to Ukraine or to we have seen in Moldova a referendum on EU accession, which was approved by a very slight margin. It seems that there was widespread fraud. And we have seen this weekend in Georgia the same. So it seems that the pretext that EU enlargement is a threat. I would like you to comment on this because the situation presently, it seems to me that it is more that the threats to European Union are more external threats than internal rifts, as it was historically, as you said. So this is the first point. Secondly, the European Union is seen as militarily or a dwarf, economically, giant, and also a model in the social state, all these things. But you see also that many European Union countries have sort of delegated their defense to NATO. In fact, we have had a very serious war in Europe after the Second World War. It was not the European Union that solved it, it was NATO in the Balkans. So I would like you to also to comment on the fact that, well, we know we have next in 8 days elections in the US, but one of the candidates, Trump, is always, or at least in the past, has been putting into question Article 5, because he says that European Union countries or European NATO countries do not contribute, at least so what they should. And this seems to me to have an effect of sort of incentivizing aggression, because if you know that Article 5 will not be upheld, then obviously it's an incentive. And one of the answers is for the European Union countries, you see like this in Poland, to develop their own defense capabilities. I would like to comment on this, and also on the scenario that if really the US leave European countries alone, you see this sort of pressure to develop their own military capabilities, even nuclear weapons, because you have only the European Union now one nuclear state, France, but it can be that we have to develop our own defense capabilities. That's the second question. Third, well, you don't see internal rifts, but sometimes, mostly because of the immigration policy, you have seen lately, for instance, we have seen in Germany that Germany has closed the borders, have suspended Schengen. This is also, by some, it's not my case, perceived as an external threat. But I would like also to comment on how do you see these differences between, you have countries like Poland or Hungary that don't have at all tolerance towards immigration, and others that are seemingly attaining, coming to their level of toleration of this because of internal policies. Excuse me for all this, but there were no questions, so...
Pedir outro, só o que queres?
Não, se calhar vou,
Cada um?
senão okay. You know, those are, of course, very interesting questions. And of course, you also understand that we cannot stay here all night discussing those questions. But,
Yeah.
but for instance,
Yeah.
last week we had in Coimbra an event organized by our Vice Rector, João Calvão da Silva. in which we celebrated 20 years of the accession of 10 European Union countries. Some of them had been part of the of the Soviet Union,
Yes.
you know, the Baltic
China,
states, for
Taiwan.
instance, and others had been under the influence of the Soviet Union, although not being part of the Soviet Union. You know, Hungary, the Czech Republic, Czechia, Slovakia, Poland, Slovenia, and so on. Of course, there are other states like Cyprus and Malta that you know, are not included in that group. But they all said that for them, the accession of the European Union to the European Union was a liberation, because they felt oppressed. They felt oppressed. They all said that. Of course, there are some rifts here and there, and they showed up in this meeting, especially, for instance, when the representative of Hungary held the floor.
Yes.
So there were rifts, and these rifts are dangerous when they are exploited by external powers. You know, because external powers, both in the East and in the West, including the United States, they can try to take advantage of these rifts. And even in a way, Brexit was some movements, maybe in the United States, trying to exploit the rifts between Great Britain and France, and Great Britain and Germany, and things like that. And so these rifts are dangerous. They are there. And the European Union has to be aware that they are there and that they can be exploited by third parties all over. So if one wants to destroy the European Union, one just has to exploit these tensions and these histories, these past histories. So we have to deal with that careful. And that is a danger. That is a danger. And we can say that Vladimir Putin was not very happy when he saw all these countries, you know, all at once, going from the sphere of influence of the Soviet Union to the European Union. Of course, the Soviet Union had crumbled, but still, Vladimir Putin thought that this collapse of the Soviet Union was a geopolitical disaster of great magnitude. So he was not happy, and of course, he sees, you know, the willingness of some Balkan countries and of Ukraine and Moldova and Georgia to come to the European Union as a threat, not as a military threat, because it will not be a military threat, but it sees a threat to the pretensions, to the imperial pretensions of Russia. And we know that Russia, the history of Russia is, you know, starting from Ivan the Terrible, is a history of colonization and power and oppression of many countries. So we have just to know history. And so this is a problem. We must be aware of that, and we must be aware, you know, that Russia is not, you know, is also aware of this. So this is complicated. As far as NATO is concerned, I think in a way, even if even if Kamala Harris wins the presidency, I think the Europeans will have to spend more money in defense. Poland is already doing that. Germany is trying to raise the numbers. Yeah, I think we are. Of course, if Donald Trump wins the election, then we will immediately have to do something about a common defense. There is already a common defense strategy. This common defense strategy will have to be strengthened, not to pose a threat to other countries, but really as a matter of self-defense. Because we know that the Baltics are not totally comfortable, and not even Finland, not even Sweden, and things like that. They are not totally. They don't feel safe. I've been recently 2 weeks ago in Romania, and I was with colleagues of Romania and other Baltic states, and they were not very comfortable with the situation. And even Finland, there was people from Finland there, and they said the same. So we will have to spend more on defense, and we will have to coordinate more the expenditure on defense, because we cannot have unnecessary duplications of material, and we have to guarantee that the material that is bought efficiently and in a way that is interoperative. So, of course, this will be a challenge. And but we have to be prepared for that. I think investing on a common defense it will be important, but also trying to explore avenues of dialogue within multilateral institutions. As you know, the United States has been sabotaging the World Trade Organization. The European Union and China and Brazil have been trying to come up with an alternative solution to the sabotaging of the appellate body by the United States. As you know, that the appellate body has lost its judges and is still vacant, and that it remains so even with the Biden administration. So the Biden administration has a strategy of continuity when it comes to the protectionist policy of Donald Trump. So they have the same protectionist policies in many areas, including steel, including electric vehicles and things like that. We all know that. But I think the European Union, along with other partners like China, like India, Brazil, and things like that, and even try to convince the United States to support multilateral institutions and peaceful ways of dispute resolution. So I think this is the way forward. But of course, we must be pay attention to the external I don't say threats, but challenges, and the internal challenges.
Yeah.
As far as immigration is concerned, we now know that some left-wing parties are now more aware that something has to be done concerning legal and illegal immigration. We know that. We know that there is a new pact on immigration. We also know that some risks remain even after this new pact. We also know that, for instance, some countries like Italy have been trying to come up with creative ways of solving the problem. I think it's another problem that we will have to face in a realistic way. We have to be realistic, but we have to be humane. So we have to be humane and realistic. So we have to strike a balance. It's not easy, but we have to strike a balance. And I will remain here, but of course we
you want to
could
add
say
something?
many other things.
The door is open to other questions and probably, I hope, to contributions and to disagreements. If it is not the case, so there is anybody? Yes, okay, fine. Yes, please.
I just want to raise a question about the EU's attitude towards the Ukraine war and the Middle East conflict. I think that it's natural. I understand that because of the closeness, geographical closeness, and then you attach a lot of importance to Ukraine war, of course, certainly. And like Professor Porto in the beginning said that it's unbelievable in 21st century to see the war in Europe. But at that time, I feel a bit uncomfortable because it's unbelievable that in 21st century we still have wars in no matter where in the world, not only in Europe. So Middle East conflict is also unsatisfactory. And how the European Union's attitude or strategy to ensure that some countries comply with the international humanitarian law. Like I see the attention to the two different conflicts given might be unproportionate. That's my thinking. Okay, thank you.
Yes, we have to take into account that there are other conflicts. For instance, in Yemen, we have had a war in which hundreds of thousands of people have died, and we don't speak much about it. Also in Ethiopia, also a conflict in Sudan, also a conflict in the Sahel area, in the countries of the Sahel in North Africa, and yeah, sub-Saharan Africa. You know that also many countries. But I must say that the European Peace Initiative, is an initiative that we don't hear much about it, but European Union has been trying to provide sometimes, when it is needed, weapons in those conflicts, and when it is needed, humanitarian help. So as a way to try to promote peace in very delicate situations. Of course, you know, the conflict of Ukraine is very important, and also in the Middle East, you know, it's a very complicated situation that comes from the British and French mandates after the First World War. You know, after the First World War, there was a French mandate, you know, for instance, Lebanon and Syria, and there was a British mandate for Palestine, for Iraq, for Jordan, and so dealing with these situations that came after these two mandates is still a very complicated thing. And of course, the Europeans are very much interested in the topic because of that, you know, because it is a complex, very complex situation that arose out of the British and French mandates, and also it's very complicated as far as international law is concerned.
I think we must close the session. I was told that. Thank you very much again to everybody, and let us hope to have a good, peaceful world for all the generations including the coming generation, including my 2 grandchildren who are here in my room. It is wonderful to be in Macau and to be hearing us, 2 grandchildren. I hope it will promote and will be in a very, very good world. Thank you very much, all of us. Thank you very much. É muito agradável ter aqui 2 netos. It is.